My name is Allie Bushelli, and I'm a junior partner here at King Law Offices.
I am Martie Wallace, and I'm also a junior partner here at King Law Offices. And together, we are in the practice area group of wills, trusts, estates, and guardianships. A lot of transactional law, we do that. And we're here today to talk about some of the little known aspects or things that people think happen but don't.
Yeah, common questions we get, things that we see come up a lot, and maybe really just some misunderstanding about estate planning, about what happens when you can't make decisions for yourself or when you have passed away. So, one of the first things that Marty and I see a lot is people come in, they're married, they say, well, I don't really need a will or powers of attorney. My spouse will get everything when I pass away, or my husband, wife can make decisions for me no matter what. And that's unfortunately not true here in North Carolina. Marty, how many times have you had that people come in your office to say, well, my husband passed away, I just need to get the land in my name? But it isn't just the wives anymore.
A lot of people don't realize that the spouse is entitled to a certain amount of money for their what they call or the law calls a year's allowance. But when there's a blended family involved and there's stepchildren, and if anything has been titled in the stepchildren's name, or that the spouse that passed away has drafted any other documents, sometimes those will come out of the woodwork that sometimes the other spouse doesn't know anything about.
Right. I've had meetings with clients where it's just wife has come in, and, unfortunately, we just live in a world where husbands tend to pass away first. But, wife comes in and she's very innocently just saying, I need to go ahead and have everything changed over. My husband didn't have a will. And we start talking, and turns out it's a second marriage. He had some kids. Relationship's okay. They met when the kids were adults. And so it's a cordial relationship, but wife didn't realize, and neither did husband before he passed away, that his kids are entitled to a portion of any real estate he owned that was just in his name. Anything that wasn't owned jointly with rights of survivorship just means that when one person passes away, the survivor gets the whole. Anything like that. And then it creates I don't want to say a mess, but it can when, one kid's like, well, I actually want to keep part of dad's property. That was something that he and my mom bought before you guys got married. So I'd like to keep part of it. And it just, becomes more of an expense that we have to try to figure out on the back end.
Often, too, Allie, what I'll see that for me is really heartbreaking is that the decedent spouse, the person who passed away, had no idea that this was going to be an issue, but it is an issue. And when you have someone who passes away, the grief, the emotion is high. And how many times have we heard, I have never seen so and so act like this.
Right.
So you have this somewhat intact, if you will, blended family that they were all getting along great. And now we have this property that's split between the second wife, the surviving spouse in this case, and we've got stepkids that can take in that, and the stepkids are now all of a sudden feeling at odds with the second wife, the surviving spouse. I've had them where it goes south quickly and there's tears everywhere, and it almost feels like we're having a divorce.
Right.
And one of the main reasons I got out of family law. And I don't know if you want to talk about this, but then you have the horribleness of a partition.
Right. If you own property with someone, co-own property with someone that you don't want to co-own it with, you have the right to file what's called a petition to partition here in North Carolina. Unfortunately, that's by usually forced sale. The court can't divide up the property equally most of the time, especially if there's only one house and maybe an acre, not even. Court can't divide that to where it's all evenly split. Right. So they're going to say, okay, sell or buy each other out. And a surviving spouse might not have all that money. And it does create some heartache when what I really want to scream into the wind is if it would have been just so simple to come in, do a will, like sit down, we'll put it all in writing, put it all like nice, pretty with a bow, and make it so much easier, so much clearer for the family too. Even when everyone's getting along, it just be so much clearer and so much less paperwork for them if there's just a basic will even.
Right. And in those instances, what I do is I just lay it out for them. Listen, if I always kill the men off first, always woman power, right?
Yeah.
So I tell the husband, if you die first, and I do say in all my hypos, you're going first. This is what is going to happen with your property, and this is what's going to be split. And then I always bring up partition. So what you could do is let's have some sort of document, whether it's a will or a trust, or even we can even deed it, which has its own situations as far as like if you're gifting things to kids so soon, but joint with rights of survivorship, that's always a good thing. But I say if there's certain things we can do, and there's lots of different things based upon how we customize it for our client's specific need that we can do right now. And better yet, we can sit down with those kids and we can say, this was my thought behind it. Because here's another thing that I find. If parents don't do that and someone is slighted or doesn't get something, even though they could have been raised the whole time that money doesn't equal love, of course. But for some reason, when someone dies and they see someone of equal status, like a sibling, get more, automatically, dad loved her more, dad loved him more. And we don't want that.
It creates a lot of animosity not having transparency with your kids, even outside. Let's say it's outside of a blended family situation. Let's say you've been married to your spouse for 50 years, you have your kids together, everyone's great. It just creates unneeded animosity amongst your kids, because while money doesn't equal love after you pass away and you're in that initial grieving process, that's all you have left.
Right.
And it's so hard to sit with someone and they're talking about, well, mom obviously didn't care about me. So and so was always, you'll hear golden child. My sister was the golden child. They loved her more. And now I can see why. Well, it could be that sister lived right down the street and was just taking care of him. And mom and dad wanted to make sure that, she got a little extra for thanks for helping take care of me. Without explaining that, without mom and dad sitting down to say, we're not doing this equally because your sister lives down the street and she's helping take care of me. There'd be a lot of fighting and could lead to what's called a caveat proceeding. I mean, you know that, which is a will contest. And that is heart-wrenching and unfortunately very expensive too.
One of the things when someone comes to me and says, this will isn't right, and mom would have never done this. And then I talk to them about what entails a will caveat. These are expensive proceedings. Oftentimes, the court, and I believe the statute, allows for both sides to pull from the estate finances to pay for these things. So all you're really doing is in a caveat. And I'm not saying that some are not very valid.
Right.
Most of them start out very valid, but then once we kind of, as attorneys, get kind of into it a little bit more, then we're seeing that, well, this is how much the estate has in it. These are, here's what may have happened to cause this will caveat.
Right.
And sometimes the proof, if you're going to be taking large amounts of money from an heir, you've got to have a certain amount of proof that the court is going to require for you to say this was done inappropriately, or mom was unduly influenced when she wrote this will. These are big hurdles to cover. They're going to require depositions. And when you think about a deposition, you're thinking about one attorney for the one side, one attorney for the other side, court reporter. And if it goes all day, I just think to myself, cha-ching,
Thousands
just
in that one room. You're right. And sometimes it's sometimes it's spending the difference. It's spending the difference in what you would have gotten if it had gone forward. Now, Martie's right. There are completely valid times you would file a caveat. Our firm has handled them before. I've handled them before. They're completely valid instances, but it's an uphill battle from the beginning to try to even get to proving your case, and most of them settle in mediation. And
Right.
but you have to go through all of that, what's called discovery or information gathering process, to get to mediation in the first place. You can't mediate without knowing what's going on the other side. That's something our civil litigation team always says. You can't mediate without knowing what's happening.
Right. And to make matters worse in these situations, Allie, they've got these emotions running rampant.
Mm-hmm.
These aren't people they just met, like in some civil litigations. You ram your car into somebody and you never met them before in your life, and now we're fighting, and it doesn't have that visceral response
Mm-hmm.
that you can have when it's with family. And I always caution people that come in and they want to do these caveats. I say, I want you to think about the things. We can surely do this for you, but I just want to make sure you're going to be an informed consumer the whole way, in that the chance of you losing this family forever is decent. But if it's valid and there's a bad actor, they probably don't want that person in their life anyway.
Right.
But the toll it can take on you, and a lot of the people who come in looking into a caveat, they are older people. And, I always say this could take years. Now, most of them don't really go all the way because of the mediation, and they realize this is costing a lot. This hurts. This is not fun. Let's get out and see if we can do a family settlement agreement,
Right.
something like that. But it's an emotional toll. It is a trial. It's a jury trial. It's in superior court.
Superior court, highest trial level court here in North Carolina, has its own schedule for how things have to be done and when and how soon. And it gets expensive. And you're right, it's a jury trial. You want to sit and accuse your sibling, who may or may not have actually done anything wrong, in front of 12 people with a driver's license, which is a jury, just proving about money and proving stuff. And again, there are cases where that is absolutely 100% what you need to do. But I'd say, what, 50% of the time, it's not worth it. It not the emotional toll. It feels like people might be taking grief out on, they're missing their parent, and so they're putting their grief in the wrong place, unfortunately.
Mm-hmm.
And it kills. It hurts us. I mean, we're happy to zealously advocate for our clients who have valid good faith reasons to file a caveat, but we're also counselors at law. If you ever look at someone's law license, it says counselor at law. If your attorney's saying it's probably not worth it, you probably should think about this a little bit. It's not because we think you have no case, unless the attorney has said you have no case.
Right.
But if it's really just trying to counsel you on if this is a good idea, it doesn't mean your claims are baseless. It just means there might be something else we could do, and there might be something that's better worth your time.
Right. That's one of the things I really love about practicing law here at King Law Offices, is that we have that human aspect that we bring out that is really before the revenue area. If we feel like this, your chances are not hot. Do you have a chance? Yes. But the kind of toll this could take on you, we're going to tell you that. At the end of the day, the choice is up to you. I've actually done this a couple times where I can tell and it's not just been just for caveats, where I can tell we're inching down a road where there's a lot coming up. Well, she always got what she wanted when she was a kid. She always got this and she always got this. And I'm like, this is not looking like, and the case doesn't look all that great. And I can tell, and then I say, what if you don't get, let's say your bill for us is $10,000. And what if what's on the line is $7,000? So either way, you're going to be out more than what the estate can even afford. And we've got the other side to think about too. What about that? I don't care. I just want her out of it. That's my cue that we need to talk a little bit about quality of life during this and forgiveness, even when it may not feel warranted, because at that point, sometimes these issues have more control over the person bringing them than they care to even admit because they're so upset. And it's always a valid, their feelings are always valid. But sometimes it takes a person to just be totally honest and say, are you sure this is what you want to do? I had it was several years ago where it was so obvious this was not a good case. We didn't have, their allegations they weren't totally baseless, but hard to rise to the level of the standard of review.
They were thin. They were there, but they were thin.
Very thin. And I just said, the amount of money that you would put into this, and I don't think that we would win. They had a child. And I said, you could go to Disney World for this time and talk about your dad who had passed away. And you could talk about dad that whole time and have the best time with your children and share memories, and while the kids are also having a wonderful time, because that's something I could think of that would cost $10,000 and have a wonderful time with your family. And you would only have probably great memories from that, where I promise you, during a caveat, you're gonna have some pretty horrible memories. And they don't even involve the courtroom. They probably involve when you're laying on your pillow at night thinking and losing sleep and having the extra stress on your body with all of this and thinking about the family that you had, anger just brewing. Now, again, on the other side of the coin, when it's a very good case, there's been a serious bad actor. Mm-hmm. That needs to be, and usually when the bad actor is that serious, there's enough evidence. Mm-hmm. And we, either through people that saw it happening, through testimony, or we have actual documentation, medical records. Mom, there's no way she had capacity to sign this.
Mom was in the trenches of dementia. She really couldn't sign off on anything. I went to the doctor with her 2 months before, and the doctor said, hey, if you don't have powers of attorney at this point, you need to consider guardianship. She really can't make decisions for herself.
Yep.
Okay, then 2 months later, she signed a will. Are we sure that she had capacity, and all of a sudden that will disinherited everyone but one child? That's questionable. And those are the days where it's like, right. Okay, you have one sibling who really did something here. And the reason Martie and I say sibling all the time is because it usually is fights between siblings. Mm-hmm. And there are other fights you can have, but that's the most common.
Right.
So you've got one sibling who really did something inappropriate, and then you can't undo it while mom's alive because you didn't know. And now you're having to fight it out in the courtroom. That is a completely different story.
Right.
That is a completely valid time to be like, okay, let's go. You can try to settle for everything being equal like it was in mom's 2 wills prior. Right. Everything was equal between the kids until all of a sudden
it wasn't.
And there wasn't a big blow up. There wasn't a fight. There wasn't anything. Those are times where, yes, it can be really worth it, but there are times where it's just so thin, and you just want to think about, okay, what can you do with the money you'd spend in the legal fees that would be more of what your parent or family member would want to see?
Right.
That father probably was like, yes, take my grandkids to Disney and have a ball, and screw what your sister did or brother did. Let's just go have a good time, put it out of your mind, That's not what I want for you.
And I use that example because they ended up sending me an email thanking me. I don't know if they went to Disney World, but they thanked me, and they thought that was very honest. Mm-hmm. I think attorneys get a bad rap that all we care about is making money, which, that's wonderful. Don't get me wrong. But I have to put my head on my pillow at night too. But when you were doing your explanation about capacity, testamentary capacity, what kind of capacity do you need to sign a will or to sign a power of attorney? That there's another big misconception, is that mom's been diagnosed with dementia. So there's no way she's going to be able to sign a will or a power of
Right.
attorney. That's a huge misconception.
Right. There's what I don't know if it's a medical term, but we use it in the legal field a lot. It's periods of lucidity. Means there are times, especially at the initial outset of a diagnosis, where someone is completely fine and it's kind of sad because they do know that they have dementia. They know they have Alzheimer's. I think of my grandmother, my mom's mom. When she was first diagnosed with dementia, I mean, she had so many windows there where she knew exactly what was going on and she knew she was sick. She could tell she was forgetting things, and she would have been able to sign new documents at that point. You know, thinking back, I wasn't licensed at that time, but, you know, thinking back, yeah, if she were sitting across the table from me, I could totally be confident that, yep, you know who your children are, you know who you're married to, you know what you own, as far as any of us know. Like, we don't have to know exact amounts in a bank account to a penny, but we know that we have a bank account at BB&T.
Mm-hmm.
You know where things are, and you know what you want to see happen to it after you pass away. That's all you need for a will.
Right.
I mean, there's a lot of legal terms that go with that. So if you Google it, you know, testamentary capacity, North Carolina, you're going to get, you know, you understand the nature of your bounty. And,
Yeah.
you know, that's very old school terms. But really, what attorneys are looking for is, okay, do you know who your kids are? Do you know who your family is? Do you know what you own? And again, it doesn't have to be exact. I'm not looking for someone to rattle
I
off a
don't know
bunch
if
of
I could do
numbers.
that.
Right. I'm not looking for someone who appraised their house recently.
Right.
I want you to know you have a house, you have certain bank accounts, whether or not you have a retirement account, cars, you know. Again, you don't have to tell me the VIN of your car, but, you
Right.
know, I have a Honda. I think it's a Civic or an Accord. I don't know. It's a sedan. That's
Right.
fine for
That's
me.
good for me. Good for me.
And then, you know, what you want to see happen and how that all plays together. You know, do you understand what it means to give one of your grandkids the car when you have three others coming up? You know, okay, that one's, you know, 10 years older. He's going to turn 16 before the rest of them. Okay, that makes sense. You know, I want my kids to have this equally, or I want one child to have more. I want to disinherit one child. Okay, let's talk about that. Why?
Right.
You know, but all of that stuff, it's not as hard nosed as people think it is. It's not as high of a standard to sign a will as you think. So when we're meeting with clients who have been diagnosed with dementia, Alzheimer's, Parkinson's, anything like that, we meet a couple of times to kind of get a good baseline for how everyone is. We talk to the family. You know, sometimes people are better in the morning than they are at night. You know, sundowning is a real thing. I've seen it in my own family. Um, so you really want to curate your representation to what your clients need. And so if mom's completely lucid at 9 a.m. in the morning, all right, we're having a signing appointment at 9 a.m. She's going to
Yep.
execute her will, and everyone's going to have some peace of mind.
Yep. That's right. And I've had that happen many times where we have, I can think of just not too long ago, just the other day. I say the other day, it was actually a couple months ago when I went to our Hickory office.
Okay.
Same situation. And she could carry on a conversation with me. She knew of her diagnosis. Just a pleasant lady. And also, too, what matters is some of these diagnoses of dementia or Alzheimer's, they have their own timeline. Everybody's different. Some can progress quite quickly, some are quite slow. But when I have someone with a known diagnosis like that, I'm always very careful about documenting exactly the questions that I ask, documenting pretty much everything, finding out when their best window is. The other thing I do, and I know you do it too, is when I meet with these clients, sometimes the first time I meet with them is just before signing, where I want to make sure that everything their point of contact has told me is in line with what they want. I've not had anyone really that I felt was a bad actor in that, where someone was saying, no, it's all me, you know, I've actually never had anyone, a point of contact, say they want me to have everything unless they were the sole heir, no other kids. But again, I make sure that that is in line with what the client says. So when I do meet with the client in person, I get them alone. You know, I tell them that this is how it's going to go, maybe 10, 15 minutes, and then we'll bring daughter or whoever it is.
Mhm.
back in, but I ask questions and I explain why I'm doing this. And it's not because I distrust anyone. I say this is what I do for everyone, because I'm sure you've seen in the news where there is a uptick. It's an epidemic, in my opinion, where people will take advantage of elderly people because our technology has changed so quickly. Everything's changed, and elderly people are, I think they're at the highest vulnerable, they're the highest vulnerable population right now. So high that Medicaid and Medicare services, the Centers for Medicare and Medicaid Services, are taking this very seriously. They're having lots of talks on this, and they are bringing, finally, now into the eye of many adult protective services, where the Nigerian prince that and I
It's the perfect example.
it
We've all
is
seen it. Yeah, the I need money so I can get my riches back and then I'll, pay you back tenfold,
right. And the problem before they were defining these types of situations with people's estates and the elderly was, you've got to be careful when someone comes to you and says, I need guardianship of mom or dad because they're spending their money this way. Well, that's not a reason for guardianship. If mom and dad, even if they're being foolish with their money, it's not incapacity to be foolish. It is incapacity when it overcomes their will and they're not totally sure. Or if they're, in one case, a lady was getting ready to sell her house and basically had no plans of where she was going to be living and was going to send the money to this man who befriended her that lived in Florida.
Right.
On a reverse search, he didn't live in Florida. He was in Nigeria, and doing bad things. And she would not listen to reason. But at the time, I wasn't sure if she just wasn't being foolish until the house thing came up. But then she consented to give her son power of attorney. And that was like one thing that I had to really make sure. Was this on her own volition? Was this something her son was pressuring her to do? And so that was a long conversation. No, I don't think so. You can revoke this. That's the other thing that can be troublesome.
Mm-hmm.
Kids talk their parents into it, and they're going to protect the money, but they can always revoke it. So they might be chasing their tail if the boyfriend gets a little more forceful. But now I think that with these new I don't know if they're statutory yet, but I know that the Adult Protective Services now have sort of a guideline to go off of when these types of things happen, and it gives us a little bit more leverage. But I think that I would feel better if DSS were involved, because I hate to make decisions like that when I'm just meeting those people. But if they have very good evidence of that,
Mm-hmm.
and get a physician statement, then we can proceed with a limited guardianship.
Right. And we had been talking about capacity and that's a big one, losing capacity. And before you do, you can sign powers of attorney. Powers of attorney are great tools and they could prevent the need for a guardianship proceeding down the road. That's really what we want to see happen. Powers of attorney can help while you're still living. I remember during COVID, we had a lot of individuals who were just terrified, justifiably so, to go out of their house. They're high risk, they're elderly, they don't want to come in contact with anyone, but they've got to go to the pharmacy.
Right.
They need their medicine and the pharmacy is not going to deliver it. So how do they do that? Power of attorney. Their healthcare power of attorney or general power of attorney can go on their behalf to CVS, to Walgreens, to Rite Aid, to Publix, Ingles. I'm going to keep railing things off. I'll stop, and pick up their medicine validly, legally, not a problem. We see a lot of times where kids are helping their parents out. Everyone in the community is just like, oh, well, that's Sally. Her mom's, not doing so great. And so she's just helping. And, everyone's fine with that. But it's not technically legally valid to do so. And you could always run into that one person, and it's usually a bank, who says, well, you can't sign that check, or you can't have access to this account because you don't have a power of attorney here. Which is true. They're being completely accurate. It feels frustrating when you're Sally sitting at the bank doing, just trying to write a check to pay mom's electric bill.
Yep.
But that's really valid. That's really what's happening. So, capacity to sign a power of attorney is higher than signing a will. But again, any attorney, I'm going to say that's worth their salt, is going to sit down and have a conversation, is going to try to see what they can do. They're not going to just give up and say, they don't have capacity, unless it's really glaring.
Right.
Most of the time, kid will know. Sally knows mom doesn't have capacity.
Right.
But if it's borderline, attorney will sit down with mom, talk with her, say like, okay, do you understand what this would mean? Do you understand you can revoke it, like you mentioned?
Mm-hmm.
And if you're the child who's called the attorney and made the arrangements, don't be offended if the attorneys say, well, I need to talk to your mom alone. It's not really because they don't trust you. It's because we got to make sure that mom, one, has the capacity to sign, and two, for our own selves. It's a CYA for us more than anything else.
Right.
It's not that we don't trust you. It's just if the state bar comes knocking, we have to show that we did this.
Also, you never know if maybe a sibling is going to be like, I had no idea that this was going on.
Mhm.
And then they fight it. Well, I want my notes to say, this attorney was on it. She was asking all the right questions and she documented all the answers that were given. And I used the is it the ADA? Or the APA. It's the
Mhm.
APA. I use their questions for contractual capacity for a PO or power of attorney. And again, I won't do it if I feel like there's not capacity there. But if I do, I make sure that I document it all really well. And I think for powers of attorney, I think it's the most under utilized or under drafted
Right.
type of document where none of us are promised tomorrow, or even that there wouldn't be a car accident. And I really never thought this, even in law school, I didn't know about this. And you know what really solidified it for me, Allie, was doing my first guardianship hearing.
Mhm.
And I thought, wow, if this person had a power of attorney, we wouldn't have to do this.
No.
And it was when I had to call the daughter it was the mom who was in the nursing home, and she was nonverbal. She really, there was no question that there was incapacity here. I had to put her on the stand. She's sitting there in front of a perfect stranger, the clerk.
Mhm.
She's speaking into a microphone because it's recorded. And these are events that I have to ask that I feel are private. They're family matters. And I have to ask, how was mom before this? Now tell me how mom is now. There's always tears. Tell the court, because the court has to make sure everything's good. How do you feel about your mom? I love my mom. And they're having to pour their heart out, very personal things that really should be very private. And now we're putting them on the record because the court cannot let just the process is appropriate. We can't just let people take over people's lives. We saw the whole Britney Spears thing.
Right.
And now we see why the court has to do this. But wouldn't it have been better if mom had already done this? She knew, she would have known who, and the court respects that through a power of attorney. And I have yet to have a power of attorney not be good enough. Have you?
No, I've never had one where it wasn't enough. And, recent changes in North Carolina law are now looking at what we call less restrictive alternatives. That was a statutory change beginning of January. What can you do that's not guardianship, that's wholly disfavored? It's not what we want to see. So we want to try this power of attorney route first. We want to try what's called a representative payee account for Social Security benefits. We want to do a bunch of things before we pull the trigger on a guardianship. And you're right, it's heart wrenching. I started working here at the beginning of my career. I've been here the whole time, and it's like, okay, I need to do this because I can just see that it's an important thing to do. I didn't really understand the gravity of it. Well, I had my son a couple years ago, And then, I came back from maternity leave and I was in a guardianship hearing, and a son was requesting guardianship of his mom, and watching him just, cry and, just be worried about his mom, and he didn't want to be there. No one wanted to be there. I think being a mom made me realize, oh, I'm not doing this for myself necessarily. This power of attorney is for me, but it's also for my son. He doesn't have to go through this if I could avoid it.
Right.
I'm doing this so he doesn't have to sit here and talk about how great it was. And now that he thinks I can't take care of myself.
Mm-hmm.
I don't want to do that. I don't want to do that for my mom. I don't want my son to have to do that for me if it can be avoided. Now,
Right.
sometimes it's unavoidable. Sometimes it's too late. And, we have things to do.
Mm-hmm.
We have guardianship proceedings and ways to go about it. But doing powers of attorney now not only saves some emotional strife for your family, also saves money. I mean, think about how much it cost you the last time you did a guardianship proceeding and fees versus the flat fee that we charge here to do a general power of attorney, which is all the finances and whatnot, and then a healthcare power of attorney. Those two documents alone will save your family and yourself time, effort, energy, emotional turmoil, money.
Emotional turmoil. So with powers of attorney, after that guardianship hearing, and I'm not even joking, that night I called my kids together.
Mm-hmm.
They thought something terrible had happened, which it had, but not like what they thought. And I said, you guys, I got to do a power of attorney. And my son, who's also a lawyer, Mom, what's going on? What's going on? I said, I had a guardianship hearing today. And he still was sure there was something more to it. And I said, I don't ever want you to have a guardianship hearing. Everything's okay, right? Even my son who's a lawyer. Why are we doing this? Why are you having to do this? Because it was on every Thanksgiving, and I've always been this way. Every Thanksgiving, I would tell the kids where my will is, and they hate it. They hate it every year. And that I love them so much, and that they're on my life insurance, and that who the life insurance is with. Mm-hmm. They know it's going to happen every Thanksgiving because I've made it that so that I never forget. Mm-hmm. Because how many times have we had clients say, I'm pretty sure they had life insurance, I just don't know what company, and so far I'm going through the emails, I can't find it.
Right.
So we didn't have that. So I made a power of attorney, and I said, well, it's not going to stop there, guys. You need to have some too. And they're like, you've got to be kidding me. So I guess we're just going to be having all these signings. And, I couldn't really be the notary. I just told them they have to pick someone that they trust. And my rule for powers of attorney, if you're going to find an agent for yourself, for me, how I tell my clients is they have to fit 4 criteria. Your agent, as far as the agent loves you, adores you, because sometimes those are different, respects you, and in your greatest time of need, and I always say you're unconscious and you're just laying there. If someone were to pick you up and put you in the person's arms that you're thinking of about the love, adoration, and respect, if they were to put you in that person standing like this, and they were to put you in their arms, in your heart of hearts, that person is going to do everything in their power to protect you because you're not with it right now. And they are going to get you the help you need. They love you, and they're going to protect you. That's your agent. If you don't have that person, I think that I almost wouldn't. I'd tell you not to do a power of attorney yet until you find that person.
Right. if you don't trust someone enough when your back is turned.
Right.
If you don't
That's
trust
a great
someone
way to say it.
Yeah. If you don't trust someone when your back is turned to have your best interests at heart and to do what you're talking about, respect, it's not just enough to love and adore someone and do what they can. They have to respect that you've probably expressed some things that they might not agree with. They might say, well, I don't think that's really the best case here. No, you need to make sure whoever you picked will respect whatever wishes you have, because why name them as your power of attorney? Why do that if you don't trust them 100%? Mm-hmm. So if you don't trust them when your back is turned, don't name them as your agent.
Right.
And And I know most people have that. With your kids, it can be hard. Naming your kid as your power of attorney can be hard because you believe the best in them. You're like, I have raised this person, I've raised them with their values, but you got to look at your kids as people too.
Mm-hmm.
You got to take a look and say, okay, as an adult, if this person wasn't my child, would they be my friend?
That's a very good question to
Would
ask.
would they be
Mm-hmm.
someone I'd want to, sit across the table with? You don't have to like all of their interests. Kids can be, they're their own people. But would you trust them to, watch your bag watch my bag?
Mm-hmm.
Are you gonna question if they're going through it, taking anything out of it?
Right.
You
Right.
know?
And that leads me to something else too. When you do have that person in your mind that fits all those criteria, I've had people say, "Can I have one more?" I say, "Yeah." Anyone who that is, let's just go down the line. And I am very hecessitant to ever do a co-agent, like where they have to agree on
I
something.
know.
I'd say if we're going to do that, then have them be able to act independently, because and then I always say, well, like especially executors, well, they get along great. There will be no problems. Then I always say, if there's really going to be no problems, they won't mind having successorship either.
One
There
or the
won't
other.
there won't be a problem.
Well, and then too, when you have co-agents for powers of attorney or co-executors, half the time they both have to sign off. Just think about how much more difficult that's going to be for the people you trust and love, and you've put this great amount of responsibility on. They're both going to have to sign everything.
And
That's so inconvenient for you, who needs probably some immediate decision making, and then for them when you don't want to be an inconvenience. And if you trust one and you trust the other, why not one or the other? Name them in order. Sometimes you name an executor and they've got some personal stuff going on around the time you pass away. They're going through a divorce, they're going through something, and they just can't add something else onto their plate. You have a backup that you trust just as much.
right. And some people, depending upon where they grew up, what culture they grew up in, sometimes they'll say, well, it definitely is the firstborn son. Well, in that case, I'm thinking of a client that said that to me, but I knew that the firstborn son lived in New York, and we had the youngest daughter living right here in North Carolina. And I'd say I totally respect that culture part of it, but from the utilizing the it, it wasn't the power of attorney, it was an executorship.
Mm-hmm.
And that's where I said, because really in a power of attorney it really shouldn't matter, because they can just go on down the line, right, for successorship. But I said it's going to be harder for that person to administer your estate because they're so far away, and that's fine, because we can do the agent here, the receiving agent of anything here. But just to keep that in mind, just to let you know. And also co-executorship,
Awful idea.
awful idea. I've never seen it turn out good.
Co-trusteeship, co-executorship, I've got one that the estate could have been resolved 6 months ago, but one person just can't bother going to a bank to sign the last document. Go to the bank where you have an account to have something notarized, or go to the post office. It's not on the other person that their co-executor is just not signing.
Right.
And so we're sitting here waiting and waiting.
And who's paying for that? The estate.
The state.
The estate pays for that. And I have a hard time finding banks that will do a dual signer. So you've got to find the right bank to do that.
Right. And sometimes it's really not even the right bank, because, something we'll talk about probably in subsequent videos is what's required of an executor once you open an estate, or, if there was no will, what do you have to do? And one of those things is copies of checks. And so banks that don't provide that, we tend to want our clients to shy away from. We don't control that for them, but we would prefer they
It's a nightmare.
It's a little bit of a nightmare. But when you've got two signers, okay, you've got to make one phone call to say, okay, check 101 was written. What was that for? Oh, I didn't write that check. Bobby wrote that check. Okay, we call Bobby. I don't remember what that check was for. And that's just additional fees. You
Right.
know, no one did anything inappropriate. It ended up being the check for the final power bill.
Right.
You know, it was totally mundane, but we don't have a copy of the check to see who signed it. We don't have a copy of the check to see who actually wrote the check. And now we've got two different people to call and we're trying to figure it out.
Yep. So co-executors, don't do it. I think that's a wrap.
I would say just thank you for yeah. Thank you for listening to our stream of consciousness.
Yes.
We hope something here was helpful. If you have additional questions or if you'd like to set up a consultation, feel free to call King Law offices 828-286-3332, and our client services team will be more than happy to set you up with a consultation.
Thank you so
Thanks.
much.